joining me today. We're going to be discussing an expansion of Emerson Bar Review and also include some other content which helps with understanding at the Juris Doctorate level for purposes of exams, some of the nuances of intentional torts of assault and battery. Now, this is number 12. We're going to break this apart and do it in a couple of segments. But I'm going to talk today a little bit about intent and also battery. And I'm going to talk about a first year torts case that almost everybody that's taken torts law in in a Juris Doctorate will have heard of, at least recently. So I ran a Google search for something that kind of characterized the case I'm going to talk about, but I really couldn't find a good image, but this is close enough. So it sometimes helps to picture things. This image here really does a good job. The guy's going to sit down and the guy's pulling the chair out as a prank. Okay, so I am also going to show you this nice diagram that Emerson wrote in his video, which is titled, I think it's titled Assault. There's one little one in the torts playlist for assault, and there's another one for battery. The thing about intentional torts is there's a long list of intentional torts, and what makes it kind of confusing, especially for new students, is that intent is not straightforward. There's so many different scenarios. There's multiple scenarios, so they have these rules of thumb when they make decisions about culpability and who they're going to, how they're going to handle the case. So this is not a case of simply intent, okay? The intent actually is broken apart. Now, with this particular one, it's for assault, okay? And I can get into this a little bit more next time, but what I'm going to give you is kind of like a broad overview of the idea of intentional torts. Now, intentional torts, there's torts against the person, there's torts against property or chattel, there's also trespassory torts and some other, intentional torts, like intentional infliction of emotional distress. You've got sort of like, now sometimes these are categorized as a crime, but a lot of times they're handled in the civil courts because there's not enough to really want to charge a person with a crime. You might get more. You'll be able to get more compensation usually in a tort case than you would in a criminal case. I mean, you send somebody away. But anyway, so let's get into the torts. Now, remember with torts, it's a civil case, so it's a preponderance of the evidence. Remember with criminal law, it's beyond a reasonable doubt. So when they're weighing the scales of justice, they use different theories and different applications. So now, here, maybe let's break this apart. Okay, so the bulk of tort law is made up of state laws or statutes and common law. Now, I've been consulting some of the outlines and refreshing my memory because it's been a while since I've been in law school. And for a prima facie case, it's got to be an act that's volitional. And volitional means on purpose, right? It's not something involuntary, it's voluntary. And so you're bringing about an effect on another. And you want to have causation, and they emphasize the proximate cause or the legal cause, which is the second of the two branches of causation normally, right? So remember that battery is the intentional infliction of bodily harm or offensive touching without consent or privilege. Sorry. Now, we can get into some details on battery a little further along. There's some things you might want to know that are kind of nuanced. Like if you're holding a plate and somebody knocks the plate out of your hand, that can be a battery of you, even though they didn't touch you, they touched the plate that was in your hand. That's just one example. Or if you have a cane, or anyway, I didn't intend to really go into detail with this. I wanted to break this apart and kind of stick to the script here. So intent is one of the areas that really gets kind of dicey. You know what intent is in intentional torts, but when you find a case-by-case analysis, you're going to find things that have you scratching your head unless you know all the different ways intent can be applied. Okay, so it can be applied different ways, and it might not be very straightforward. So let's say you, like the example I just gave you, did a person intend to commit a battery? Well, did it fit the intentional infliction of bodily contact, harm, or offensive? Take it apart. Well, they didn't touch my body. Well, what? It was indirect, right? So anyway, intent can sometimes be indirectly established by direct evidence of other types of behaviors. So let's say if a defendant intended to cause an effect with a volitional act, it's not something involuntary like an epileptic seizure, it's something really voluntary. Okay, volitional voluntary movement. And then they had the purpose. Maybe they just wanted to get your attention, and they were upset, and it was impulsive, but they had a purpose other than they didn't really mean to hurt you, but and there was nothing in your plate, and it was a plastic plate, a paper plastic plate, very lightweight, and it was empty. You hadn't even filled it yet, and they just wanted to get your attention, but something happened and it set out a chain of events. It was a purpose, and it wasn't the end result that you had to the actual damages that were caused, but nonetheless they'll let the fact that you did something maybe a little rude and intentional to substitute when a person has damage for a suit for assault and battery or battery. So the intent, when you break it apart and you have to have the intentional component, okay, you're gonna hear about all kinds of different scenarios, and you're gonna say, well, this is intentional, but it's not, So that's why we have a couple of different substitutes to be fair in the scales of justice. So remember, with knowledge of substantial certainty. So the defendant had substantial certainty to bring about an effect which resulted in the harm. It might not be the harm they expected or intended. They might not have intended, oops, sorry, I didn't mean that, but this is what happened, but I did mean this, and the end result was that, right? So, yes, you can still get in trouble, even if you made a mistake like that. So, transferred intent, there's two ways. Either you're going to intend to do something to one person and it happens to another. Now, this is with torts. It's not with criminal law. There's a little bit of difference between criminal uh, and civil cases, okay? So let's just focus on the civil tort. Okay, so to affect a particular person, and then so basically, there's an intentional tort against a person. There's an intentional tort against a property, things like conversion, and so on and so forth. So, transfer and intent, two ways. Intend to defend, so basically, you might intend to do something to some property, and you do it to another piece of property, or you intend to do it to another person, and something happens to another person. So it's transferred because you did have intent, but maybe it didn't come out the way you intended it to come out, and you're saying, oh, I didn't intend it. But hey, you did intend to do that act, and you did do the act, and it resulted in this, but it wasn't what you intended. It's still, you're going to be held as intending it. Okay? And then finally, causation. They're focusing on the proximate cause or the legal cause of the tort. So sometimes substantial factor can substitute for cause. Okay, now I'm going to give you the prime classic case, GarrattV.Dailey. Now, you probably remember this from first year if you went to law school. So basically, this is a case that went on appeal. You could probably Google it and find loads of briefs on it because it's a classic case brief. And I guess the case went up on appeal, and on appeal, so first, Brian Dailey was a 5-year-old, okay? He was a nephew. He wanted to sit in a chair. And his great aunt, which is Garratt, sued Brian Dailey. Now, she was elderly. She had arthritis, maybe a little osteoporosis. Her bones were thinning. And they're at this picnicky party, and everybody's going around, and he wants a chair, and he sees her getting ready to sit on the chair, and he says, I know. I'll nab that chair from her, and I'll get the chair. 5 years old. Actually, they make a big deal over the fact that he's 5 years and 9 months. But basically, he nabs the chair from her. As she's sitting down, she falls to the ground and breaks her hip. She has to be rushed to the hospital. She's got all these hospital bills. And she's laid up in bed with a broken hip. Can't walk for months because her nephew decided he wanted a chair. And he didn't intend to break her hip. But he substantially was certain he was intending to get the chair, right? So this case, first, he won the first round, and then the second round, or was it the third? It's been a while. All right, let's find. I'll tell you what I'm gonna do. I'm gonna Google the case just to be double sure. Let's see what we can find here. So I basically used for the thumbnail there some Google images. Now, look, you can just Google this. LexisNexis has one. I do have a subscription, but I'm not logged in. Court Listener, Wikipedia. Wikipedia is probably the best one to go to simply because they don't run ads. And a lot of these other ones run ads, and you're not supposed to show other ads. So let's just look here. Okay, so it says background. Now, remember when I talked about shepherdizing a case? That simply means look at the case history and check to see if there's another subsequent case after it. So this was appealed to the Washington Supreme Court. It's Washington State. And it was about the lack of intent to cause harm precludes a battery charge. That's what they heard. So on appeal, she sued him for battery, and she lost. And she had really serious injuries. It wasn't some sort of frivolous case. And Now, here's a couple of different things you can learn from this. Okay, so it was the Washington Supreme Court. So the court ruled, I think I read this in Prosser. I can't, I've got some of my old books, but anyway, so this is the thing about intent. Okay, so I actually, here's the playlist. I will try to put the playlist below, but these are the intentional torts: assault, battery, conversion, trespass. Now there's others. Oh, here's the whole playlist. Great. Okay. So what can we learn from this? He did not intend to hurt her, he maintained. In the lower court, he won. In the upper court, they reviewed it a little bit more thoroughly, and they said, no, we think the lower court made an error because there was the substantial factor test, okay? So, and when they wrote the opinion in that, they used the word substantial certainty. So, now, next time I'm going to go over something similar to what I did in the negligence. I started with negligence because negligence was 50% of the testing, and the other 50 is miscellaneous intentional torts. Pretty much went through the products liable, but I think there's a little bit more because it uses contract law too. But with intentional, there's some overlap with the idea of causation and everything, but as you can see here, they mostly focus on the proximate legal cause. And the other thing is that this is intentional, right? And there's a whole list. It's based on common law mostly and statutes. So what I would say is that when I went through negligence, I talked about whether or not a person was insane or whether a person was child, and whether or not they can be held liable as a child. Now, in this case, as you can see, Garrett was 5 and he was held responsible. Now, generally speaking, unless parents are negligent or the parents are encouraging the child to do something wrong, the parents are not held liable. The child is. But there is a vicarious liability element. We'll get into that more later, but this is just an example of how intent can be applied, and it's not always obvious. And sometimes a second court or a second set of eyes or ears gives it another look and says, no, I think the lower court made an error. So that's it for today. I want to thank you for watching. I will be going over assault and battery and intent and these different ideas again, and add on to this in the next video. So this will be it for today. Thank you for your time and attention. Bye.